So I am Delegate Sia Price, and I represent the 85th District in the Virginia House of Delegates, and I have served there since 2016. And in that time, I've met lots of people. I've learned a lot. And one of the things that has been consistent is that people need access to more information and resources. And so, what we've been trying to do is make sure that everybody has the information they need in order to make the best decisions for themselves and their families. And so, it is National Make a Will Month. And so, with that, we wanted to make sure that you all had the information that you need in order to best protect your family. So, I know a lot is going on, but we have to multitask and make sure our families are taken care of. So, thank you for making time tonight. If you have questions as we're talking, you can use either the Q&A function or send a question to the hosts and panelists in the chat. And then after the end of this, we'll have a follow-up email that will go out that will contain a recording, links and articles and anything that comes from the conversation, and that will go out by Friday. We do want you to know that this is a no judgment zone. We have an expert for a reason because not all of us are experts on this topic. And so no question is dumb, and we want to just make sure that we're all here to learn. Also, just to let you know, we do have an attorney present, but this is not legal advice. This conversation this evening is for educational purposes. So if you have specific questions for your particular circumstance, you would need to talk to a lawyer to get specific information. So tonight is just educational purposes. And before we begin, we're going to launch a poll. And if you could, on your screen, answer these 4 questions. Rate from 1 to 10 how much you know about wills and trusts, 10 being like you're an absolute expert, 1 being like, I think I know what those words mean. And then we also have the question of, have you completed a will? Do you have an advanced directive, healthcare directive? And do you have a durable financial power of attorney? And so, like, no judgment on these, but if you if you could answer those questions, and then we can just kind of see who all we have in the room, and break information down or can make it concise as much as possible. So we'll give it another few minutes for folks to answer their questions with no judgment. So rating how much you think you know about wills and trusts, 1 being nothing, 10 being everything. Do you have a completed will? Do you have a complete advanced healthcare directive? And do you have a completed durable financial power of attorney? Okay. So thank you all for your transparency in this. This is a completely anonymous poll, but we are seeing that there's a very degree of how much knowledge we are bringing to this event. So I appreciate that. We do have some ones in the building. Welcome. And so we're glad that you're here because we're going to get you to a higher number talking about that. But I don't see any 10s yet, Rebecca. So we don't have any other experts in the room. But we do have a few people. We have 5 people that have wills. And then most of us either don't or are working on it. And then we have 4 with an advanced healthcare directive and 3 with a durable financial power of attorney. So this is super helpful. I really appreciate you answering that because it lets us know, like we said, kind of where we are. So I'll just share those results real quick so you can kind of see you're not alone. We're all coming to this from varied levels, but one thing is for certain. More of us need to get on top of getting our affairs in order. And that's why we're here. So again, no judgment. I want to just start with level setting, because this is just a perfect time to have this conversation. But as some of you know, end of life issues are very heavy on my mind right now as we continue to grieve the loss of my mom. Um, but even as we are experiencing the hardest thing I've ever gone through, I know that whatever I'm feeling and going through would have been exponentially worse if I was crying and had to go to court, or if I was like trying to get myself out of bed and had to go fight to keep her belongings within the family. But my mom gave us such a gift when she made sure that her affairs were in order. But we don't always get that diagnosis or that warning that our time may be coming to an end soon here on earth. So it's important that we stay ready and take action today to protect your financial legacy. And so with that, I could not be happier than to have Attorney Rebecca Winn with us, who just has a heart and passion for this work that you will soon hear. Attorney Rebecca Winn graduated cum laude from Old Dominion University, earning a bachelor's degree in political science, and then went on to graduate from law school, earning her Juris Doctorate. And then after earning her law degree, she earned, that's a post-law LLM?
Yeah, if you're an attorney or a judge and you get an so it's a master's degree if you're not an
Okay,
attorney. If you're an attorney or judge, it's kind of like a postdoctorate. It's like a special
awesome.
degree.
And that was in environmental law. But she's now an attorney in private practice here in the Commonwealth in general practice areas of civil and criminal litigation and contract negotiations, and has a specialized interest in areas that include family law, estate planning, guardian ad litem representation for both children and incapacitated adults, election law, redistricting and gerrymandering, all kinds of things, including civil rights. And because of her love for voting rights and her call to serve, Rebecca is the vice chair of the electoral board of the city of Hampton, which plans and oversees all elections for the city. She's also an amazing mother and active member of the NAACP. So it is my honor to now turn this over to Attorney Wynn to walk us through some basics, and then we will go to further conversation and answer your questions. So don't forget, if you have questions, you can put them in the chat, or you can use the Q&A feature. Rebecca, I'm going to turn it over to you.
Okay, great. So, Sia is going to help me out with the slides because while I'm pretty tech savvy, I still have my gray zones, and this is one of them. So we're here to talk about estates and life planning tonight. We can move on to the next slide and kind of talk about why it matters. Historically, uh, and being the reason that I actually got into this is that I have a heart for historically marginalized communities. And we live in a capitalist society. It's got its goods, its bads. And for whatever it's worth in the United States, the majority of wealth is not actually earned. It's not the whole pull yourself up by the bootstraps concept. It's actually accrued through the process of generational wealth. What does that mean? It means inheritance. It means one generation passing that wealth on to the next. And so the best way for people to protect wealth is generationally. Historically marginalized communities have not had access to competent attorneys. They've, for whatever reason, perhaps they're in a legal desert and there's not a lot of attorneys around, or perhaps it's been unaffordable. And as such, they have been unable to get their estate planning, their life documents, or their life planning documents in place to include a will. Historically, it's been weaponized against marginalized communities as a way to take land away. During Reconstruction, the African American community held like 10% of the land through different mechanisms and means and structural harms. The land has since been taken away from those marginalized communities. And last time I checked, it was like one half, maybe 1% of the land is owned by African American communities. And a lot of that has to do with a lack of a will. And when it falls to the law, then you'll end up with like all the siblings having equal share in like one land. And then they pass without a will. And then you end up with like 10 or 15 different cousins that have equal shares. And it only takes like one big company trying to pick off one person, and they can force a sale on the land. And then next thing you know, the family's wealth is gone, right? So so yeah, it matters. Historically, it matters. Protect your wealth. And the laws there, we have great legislators like Marcia that creates the laws that allow people to protect themselves. So it's just a matter of being informed and knowing how to use the law to protect yourself, to protect your family, and to protect your future generations. So we can go on and talk to the next slide and talk about some of the basics. So life planning in general, what does it mean? This is how you can use your voice. The law allows you to use your voice while you're alive, so you can speak for yourself should you ever become incapacitated while you are alive or at the time of your passing. So there's three basic documents that everybody should have. So two of them, your Advanced Medical Directive and your Durable Power of Attorney, are alive with you. You use those during your lifetime, and they pass when you pass. And at the time of passing, those two documents no longer have any effect. And at that very moment, a will, should you have one, springs to life. And that is when your will, that's when your will takes effect. So we're going to talk about the two documents that are alive with you first. So when people talk about needing to care for themselves, the law kind of looks at it in two pieces. You can care for your physical person, and you can also care for your financial life, okay? So your Advanced Medical Directive protects you, as in your physical person, and provides for your own care during your lifetime. Now, and you name an agent, and it basically leaves instructions to the agent. Like, this is what I would want. This is the quality of care I would want for, and in all of these different circumstances, these are the decisions I would want for you to make. Now, can an agent just come in and make decisions for you at any time? No, no, no. That's not what an advanced medical directive is intended for. It is intended to empower somebody to be able to take care of your physical person should you become incapacitated. That means should you be in a situation where you are no longer able to make decisions for yourself. Perhaps you are under anesthesia and it's only temporary, but somebody needs to make a decision while you are under the anesthesia. Perhaps it is more long term, and at some point in your life, you begin to suffer from symptoms related to Alzheimer's or dementia. Why would you need to have a document like this in place outside of the obvious? Like Marcia explained, it's a gift. It's a gift to yourself because you are able to use your voice, and you are empowered now to be able to make decisions for yourself, so that way nobody can take that away from you. Also, it's a gift to others because not only does it alleviate the burden of having to figure things out and try to determine what the right thing to do is, but it can be very emotional when you're making decisions for your closest loved ones. And so it alleviates a lot of the guilt that sometimes can be associated with certain decisions. For example, if somebody has to make a decision with regard to life support, whether to maintain life support or whether to go ahead and let somebody pass naturally, that can be a very heavy decision to have to make. And when somebody finally comes to a decision that they believe might be in the best interest of the person, they then have siblings that have their own opinions that can differ, or cousins. They have other family members. When everything is in a writing, there is no ambiguity or no room for arguing or for bickering over the care that this person has already stated clearly that they want for themselves. Another reason to make your own advanced medical directive is oftentimes when you go in for, say, a surgery, and you don't already have one filed with all of your medical care providers, it is very normal for a hospital to give you a generic form. So, like a generic advanced medical directive. Now, their attorneys that work for those hospitals have created these boilerplate forms. And it's really guided towards like what the needs of the hospital are, so that way they know what to do. When it should be a document that's built around your needs, the unique needs of the individual. So let's move on to durable power of attorney. That's going to protect your financial life. Why do you need that? So let's go back to the example of the person who, say, has dementia or Alzheimer's, or perhaps a person who may be in the hospital under anesthesia or may be receiving some other form of long term care. Meanwhile, they have a mortgage that needs to be paid. They have health insurance premiums that absolutely need to be paid so that way their care can be continued. They have medical providers that need to be paid. They have the electricity bill. All of the normal expenses, all of the normal day-to-day bills are still accruing. Your children, for example, are not going to be able to call the power company and say, hey, we need to get mom's account information, or hey, or call AT&T and say, hey, mom's not using her cell phone right now, so we need to temporarily suspend the billing or suspend the device billing. They're not going to allow somebody to access an account or make account decisions such as cutting off a cell phone unless they're if they're not already on the bill. But having a durable power of attorney um, uh, 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 gives somebody the authority to be able to go in and maintain your financial health and the health of your financial life when you are incapacitated. So again, this does not mean that somebody can come in and the person you name as your agent can just say sell your car. It is only when you are incapacitated, and it's only if the authority to do something like that is even granted within the durable power of attorney. So again, those are very important to have during your lifetime. What might happen if you don't have those? Okay, well, you still have needs to care for yourself and to care for your financial life. If you don't have those in place, what will typically happen is you end up in court, and there's an attorney like me, and there's also an attorney for the hospital or for the long-term care facility, and everybody's arguing in court as to whether a guardian, who's going to be the guardian and who's going to be the conservator. A guardian takes care of the person's physical health, the conservator takes over the financial health. And oftentimes, what usually happens is the attorneys for these long-term care facilities will ask that Jewish Family Services or Catholic Charities be appointed, and then you end up with somebody who you don't know. And these organizations are nonprofits. They're reputable, good organizations. But the reality is, you have people who you do not know who are making decisions over long-term care and very serious decisions like life-saving procedures over your own life. And they also have financial control of your life. They can sell your car or sell your home in order to help you get qualified for Medicaid or some other insurance or whatever you need in order to continue to afford the care. So to make sure that your loved ones and the people that you trust the most are able to make these decisions for you, you get to name who's going to take control, and you can avoid these courtroom battles. So that's what happens during your lifetime. At the time of your passing, you then have a will. A will is kind of like instructions. It does not help you avoid court if your estate is valued at over $15,000. Last time I checked, that was the amount. I haven't looked at the law in the past year or so, but last time I checked, it was around 15,000. If the value of your estate is worth more than that, so that means the total of your car, your bank accounts, do you own a home? If all of that together is more than 15,000, you are going to end up in probate through the court system. But this allows you to give instructions and say, this is where I want my estate to go. This is who I want to get the house. This is who I want to have the car. or my bank accounts. So it does not necessarily help you avoid the probate process, but I can give you tips and tricks on doing that in a few. But it does allow you to leave those instructions. Virginia law provides a really cool provision where you can actually leave a list. If your will is drafted properly, you can get creative and add a list to your will that you can change at any time without harming the will itself. So if you change your mind on like a watch collection or who gets the big screen TV and items like that, a properly crafted will can account for those things with it that and do it in a way that allows you to adjust on a more regular basis without having to touch that will document. Um, if you do not have a will, the law is there to protect you, and it falls to the legal term is intestacy. So the law will say who gets what. Um, if you are estranged from your spouse, the law does not care that you are separated. The law only asks if you have been divorced or if there's a property settlement agreement or a separation agreement. It can be referred to in different ways. But if you don't have something like that in place, if you do not have a final decree, you're not divorced, and there's no separation agreement, your spouse gets everything without a will according to the law. You can't completely cut your spouse out with a will, but you can protect a lot of your assets. They're going to at least get their marital share. So if you're separated, that's something to keep in mind. Get your will in place. um if you are also, it protects your children. Let's say you've remarried. You want to make sure that your children from a prior marriage are protected. You may want to. You can do a lot of different things with a will beyond where your estate goes. You can say your final words to people. Sometimes you can leave meaningful messages to people through your will that might help your grieving loved ones, and just let them know your final thoughts and advice that you would like to leave them with. You can also do some really great and cool things with regard to telling people how you would like to be buried. Perhaps you're very religious and you want to make sure that your burial complies with your religious requirements. You can do that. Perhaps you had a love for science. I've helped many professors, and their their burial wishes have been expressed such that their ashes are spread in the area where they would collect specimens for research, meaningful things like that. So you can get creative, and you also don't have to go to an attorney. Virginia law is really cool in that it also allows for people to make what we call holographic wills. That means a will that you write by hand. So while I will advise you to absolutely go to an attorney because they can help craft a will that truly carries out your intent and make sure that all the areas of your life are covered, do not delay, or do not feel that it's not for you because of the barrier of an expense. A holographic will is an option, temporarily or for the long term. All that you need for a holographic will is that the entirety of the document be in your handwriting, and that it's preferable that you have two witnesses sign it. So what you want to do, you want to have the whole thing written out, and then right before you put your own signature on it, have two people with you who don't have any interest in your will, preferably, so they're not getting anything out of the will. They watch you sign it, and then they sign it as your witnesses. That's the preferable way to make a holographic will in the Commonwealth of Virginia. Though the rules may be different in other states, so definitely check. And if you're not from Virginia, and you'll want to check and see you'll want to seek legal counsel in any other state. So we can go on and talk about some of the extras. So the extras, the needs of an individual or a family unit, the needs of a family unit are as unique as the individuals that make up that family unit, right? And so these extras are not necessary for everybody. Those three basics that we spoke about earlier, I highly encourage everybody to have one. Anybody who's 18 years or older should have the basics. The extras are tailored to you. So trusts. As we age, oftentimes people will end up in what we call long-term care. That could be skilled nursing care. Um, there's different levels depending on how much medical need there is, but a long-term care facility is where somebody will typically be when they need medical assistance day to day. So, like a nursing home, right? Those cost money. For anybody who has never had a loved one in a nursing home, on average, I would say the median amount here in Hampton Roads, it's about $9,000 a month. And I'm being generous with that because there are plenty of places locally that are far more expensive. $9,000 a month. Now, there is this piece in federal law. I hate the way it's written, but this is what the law is. After a certain period of time, I believe it's 3 months, the last time I checked, if you are no longer showing improvement in if you're no longer showing an improving course of your health, then it's not going to cover anymore. And so at that point, you're in one of three categories. Either you're one of the few remaining individuals who still has long-term care health insurance. Health insurance companies do not want to give these policies out anymore because they don't make money off of them, because the coverage is so amazing. If you do have a long-term care policy, hang on to it. Your insurance company will tell you that you don't need it. They're going to try to do everything they can to get you off of that policy because that's how they make their money. Keep your long-term care policy. It's amazing. If you are the majority of the people, the vast majority who does not have a long-term care policy that will then supplement your Medicare or your primary insurance, right? So if you don't have that supplementary policy, then what happens is either you are paying out of pocket $9,000 a month, right? Or you're on Medicaid. Now, in order for you to qualify for Medicaid, you cannot have more than several $1,000s to your name. There are some exemptions. For example, you're not going to have if your spouse is living in your home or if a minor child is living in your home, then the home will be exempted from that math, right? But they're going to look at your cars. Do you own cars? Do you own bank accounts? Do you own stocks and bonds? And if all of that is more than just several $1,000s, then you will have to pay out of pocket until you fall below that threshold. So what a lot of people do, historically, the haves, this is what they do. They make trusts. You've heard the term trust fund babies. This is how generational wealth is accrued. Most generational wealth is lost because of these long-term care expenses that basically siphon off everything a family has accrued at the end of their life. So creating a trust is the way to do it. In order to qualify for Medicaid, if you have your assets in an irrevocable trust, meaning you can't undo the trust, okay, and you've had them in, that's called a 5-year look back period. So as long as it was in the trust prior to 5 years before you needed this long-term care, then they're not going to count those assets against you, okay? So you can create trusts that basically say everything in this trust is irrevocable, so I can't remove it, but the trust now owns it. A trust is think of it as like another person, right? It's almost like being its own entity. And everything in this trust is my name's Rebecca, right? So everything in this trust is meant to take care of Rebecca during her lifetime. And after the time she passes, anything that's left is to take care of her son. My trust can say that. So you're still benefiting from everything you earned, but instead of you technically owning it, the trust does. And that preserves your wealth for yourself and for your long-term care. So that way you're not having to pay it all down for your long-term care. And instead it allows you to qualify for Medicaid as a supplement. So those are going to be your three categories. Again, you're going to end up with a long-term care policy, paying out of pocket, or you're going to qualify for Medicare. I'm sorry, for Medicaid. And just because you have accrued wealth does not mean you cannot qualify for Medicaid. It just might be that a trust, an irrevocable trust, is good for you. If you have adult children with special needs, perhaps an incapacitated adult child, there's other forms of trust that you can protect them with, like special needs trusts. So there's all sorts of different kinds of trusts that are tailored to your unique needs. But for the purposes of this conversation about protecting generational wealth, an irrevocable trust will be the way to do it. Um, and I want to make mention also of having a power of attorney in loco parentis. You can see that at the bottom of the screen. That's a great thing to have. If you are a parent with a child, a minor child, so between the ages of 1 and 18 years, you should have one of these in place. I did from the time my child was very little. So basically, it said in layman's terms, if I'm out of town or you're not otherwise able to reach me, my mother's name, my father's name, they're authorized to make any decisions that I am unreachable and unable to otherwise make for myself. So if somebody is like, your child fell out of a tree, we need to perform surgery, should we keep the leg or not? Some tragic thing like that, and they're not able to get a hold of me. I don't want strangers making this decision for my child. It authorizes my parents to. If for some reason I'm in Europe traveling and I can't, something happens and the airlines shut down, but so I can't get back in time to register my child for school, it authorizes my parents to register my child for school, and the document is only in effect for so long as I am not myself able to do the thing for my child. So it empowers other people to have authority to make sure that the necessary needs of your child are being met. So definitely look into it. I highly encourage having one. And then we can move on to the very last slide. This slide is great. You don't have to wait to get all these documents in place. You can take action now. You don't have to wait till your will is in place. You can do things that not only are immediate, but will get you around probate. So the whole thing about having to file with court and any of the expense associated with that. What you can do right now is called payable on death or transfer on death designations. What does that mean? So you have a bank account, right? For whatever reason, you don't want to add your child, you want your child to have the contents of the funds in your bank account when you pass, and you know which child you want to have it, but for whatever reason you don't want to add them as like a joint account holder now. What you do is you go to your bank and you tell them, I want my child to have my bank account at the time of my passing. What do I do? They're going to give you one-page form. It is so short. It will take you 5 minutes to fill out. You designate your child's name, you list their name, or it can be more than one child. You can say all four of my children in equal parts, or I want it to go to child A, but if child A passes before me, then I want it to be child B. You can do all sorts of things with your designations. You list your designations, you say who you want to get your bank account, you sign it, it's done. You can do the same thing, payable on death, for your stocks, your bonds, your investment accounts. If you have a life insurance policy, Virginia law, our General Assembly passed a more recent law that even allows you to do this with the deed to your home. You can do a transfer on death deed. Most people should be able to self-navigate that process, but it's still kind of tricky enough that people will often come to me and have me assist them with that. So basically, you go to the circuit courthouse where that property is owned. So your home, any real property, a piece of land, anything you own, you go to the circuit court where that property is located. And you tell them, I want to list a transfer on death deed. It's some forms. There are a couple of forms to fill out, a few things to file, and it's done. That person, so your child, your best friend from high school, it could be the NAACP, the SPCA, it could be your alma mater, where you went to college or university. You can leave the home to anybody you want through that transfer on death, and they don't have it during your lifetime. You can change it at any time that you want. You can revoke it if you want. You can go back there and change your designations, but when you pass, it falls outside of probate. It's immediate at the time of your passing, and the circuit court will automatically recognize um, the person that you designated to own your home. And so it's a way to get outside of having to go through that probate process. So if you have an account anywhere, an investment account or just a savings account or a financial account, ask about payable on death designations. It's a great way to get outside of probate. And then if you own any real property, think about looking into filling out a transfer on deed. So that way, again, it's a way to get things done outside of probate. Otherwise, that's kind of like an overview of different things you can do. And I hope it was helpful. And if anybody has any questions, I'm here.
Rebecca, thank you so
So
much. We do have a few questions, but I want to start with so so I have heard when I when I was circulating the flyer for this event, I did hear from some of my friends that were basically thinking that they don't own enough in order to warrant a will. So they might rent property, they might lease a car, they might not have any kids. But as you were talking, it's like even what happens to your body can be, in that. So can you talk a little bit more for those that, may not identify with like the rich or the wealthy, but they still have decisions that can be made in the will?
So as I explained, like the majority of wealth in our country is accrued generationally, right? And the only one of the big things that separates that creates wealth inequality is the lack of these documents, right? So just because you don't feel like you have something now doesn't mean you can't preserve what you will have in the future. Okay. So what I tell everybody, if there's somebody I know who's graduating from high school, the best thing to get for somebody's 18th birthday or as a high school graduation gift are your basics. Get them a will, get them an advanced medical directive, get them a durable power of attorney for financial needs. Why? You would say an 18-year-old or high schooler doesn't have anything yet. You don't need anything to have those documents in place. They can express their intent for anything they have now or in the future. It can simply say any real property in my name at the time of my passing, this is who I want to go with. This is who I want it to go to. Life changes. You don't have to specifically identify things. You can be more general. Like any cars owned in my name at the time of my passing, I want it to go to my mom. And you can change. I just generally tell people they may want to seek an attorney, or if they can't afford one, look at it themselves. But their will should be reviewed like every 5 years. But you don't have to own anything. And oftentimes, your will cover things outside of property ownership. And again, as Marcia exampled, you know, what you envision for your burial. You can say, I want the music that I like. I have a CD already made, and you're going to find it in my desk. And I want that CD to be my music. I don't want any boring music. And this is a list of the people that I want to talk at my funeral. Like you can do all sorts of cool things. You can say all of your final words to people, like, I liked you, but I didn't like her. You can do whatever you want in your will. So it's not always about property ownership.
No, I appreciate that because I was joking with some of my friends. I was like, even if it's your like Labubu collection, it's still yours and you still get that voice over it. And funny enough, like my grandmother in her will documents and things, she had the obituary written. She was like, this is how my story will be left. And I admired that. Like I'm not ready to do that just yet personally, but so I don't have that much detail in my will, but she had even written it down to that. So then we do have some questions, and so the first one is, do husband and wife have a say so over one another, or are the will and the power of attorney still needed?
Okay. So if you pass without a will, or without your power of attorney or your advanced medical directive, then the husband and wife will get, so they will get a say in the example of an advanced medical directive, or in the example of a will. If there is none, the husband or the wife will get the others. Now sometimes what a husband and wife will do, they'll come in together and they'll ask for reciprocal wills. So basically the wills mirror each other, so that way whoever passes first, it's going to naturally go over to the other, but they want to know that the other person has made similar arrangements, right?
Yeah.
Um, but sometimes people will say, "Well, I know you can change your will if I go first." and I don't want you to be able to do that. So what we're going to do instead is a trust. It's a little trick people will do. Um, but you don't, if you're a husband and wife, you don't have to do that. You can go make your own will and you don't have to include the other. Now, there are certain provisions. You cannot exclude a spouse. You can exclude anybody except for your spouse from a will, but they're going to get a certain marital share. So a certain percentage of your estate, even if you try to exclude them. But you can preserve up to 2/3 of your estate by having a will if you don't want your spouse to get all 100%. So let's say you have a child from a prior marriage, or you want to make sure it just goes straight to your kids or whatever. So it doesn't have to be that your spouse gets all of it.
Awesome. And then I think, there's some nuance too that we can talk about some of these. This question was, why get a TOD for properties over a trust if all the other money is under a POD in various institutions? And I just want to remind folks that some of these forms and some of these things do require lawyers. And then, some may not. So there's access, right? So if you have all the access, all the money, go get the attorneys, go, do everything. But we're trying to offer options, so people have all the information so they can do what they can afford, but also what fits best for them. But would you add anything to that, Rebecca?
So they're just different choices people can make, right? And so what our General Assembly is trying to do, they are trying to acknowledge the historical harm that lack of access has created and this economic inequality. And in order to create more equality, we have to create equity, right? And so General Assembly does that by passing laws that empower people to be able to do things on their own. And so having a trust is great. That is all inclusive. That is the way to go because it's allowing you to qualify for your Medicaid as a supplement. It's giving all the instructions. It's doing all of it in this one-stop shop. You've paid like $5,000 to an attorney to have everything done, but some people can't afford to do that. And so instead, what they can afford and what the General Assembly has acknowledged and empower people to be able to do is to kind of do this piecemeal, right? So you can say, I don't have money to go get my trust done, but I can pay, I don't know how much it is right now. It's like $60 or $75 or whatever the filing fee is for the circuit court, just to go down there and get the paperwork filed so I at least know my home is taken care of. And
Yeah.
while a trust is more all-inclusive and holistic, it doesn't mean just because you can't afford that doesn't mean you are without avenues for self-help.
Right. And then there are some questions about, I guess, the taxation of the different things. And so, for instance, will do payable on death versus transfer on death items, are they taxable in the probate process? And I think that's trying to weigh it out between, knowing that some things in the trust would not be taxable upon, receipt.
So to be clear, I do not practice tax law.
Okay.
But what I can explain is that in Virginia, there is no inheritance tax per se. There are fees. So, like if you are going to be, if you're an executor of a large estate, you're going to have to get a bondsman. People often associate that with like having to get bailed out of jail, but you would also get a bondsman if you have a large estate that you're having to facilitate. So you're having to pay the bondsman. That could be like $1,000, $2,000. It depends how big the estate is. You're going to have to pay costs and fees to the court. It's not taxes, though. It's just costs and fees to the court. Also, you oftentimes, whoever's the executor or the administrator of your estate, they can oftentimes take fees for their work and their time administering the estate. So, by doing transfer on death and payable on death and doing all of your designations ahead of time, you're avoiding those costs and fees that are otherwise getting paid out. Now, it might be that somebody, because now they've now accrued, a dollar value, be it in the form of a bank account or a car or house or whatever they've gotten, that might be something that's taxable because that's now income. But I'm not a tax attorney, and that's definitely something for you to seek a good question for a financial advisor or a tax attorney.
Thank you for that. This question is, will the look back consider if you are the trustee of the irrevocable trust to hurt your asset protection and benefit options?
Okay, so if it's an irrevocable trust, if you're the beneficiary of the trust, right? Is that what you're saying?
I
So
think
you
that's what the question is.
can be the beneficiary of the trust. So the trust can say, I could have a trust right now and I could have set it up 10 years ago. And it says, and so every month when my paycheck comes in, it goes directly to the trust account, right? So now the trust owns it. I can never pull it back out because it's irrevocable, right? But the trust can say, everything in this trust is to benefit Rebecca Winn, and it can be used to pay all of her living expenses, her mortgage, her car payments, and to be used for like food, medical expenses, and any educational needs. So it can be specific about how it's used, and as long as it's for Rebecca and it's for any of those things, that's what this can be used for. And I can be the beneficiary of that, and it's an irrevocable trust, and it would still allow me to qualify for Medicaid because I don't actually own the money, the trust does. But if it has to be in an irrevocable trust, if it's in a revocable trust, that's a different story, and it would count
Okay.
part of your assets.
So yeah, so I think it was like, what if you're the trustee and beneficiary regarding the irrevocable trust? And so that was your answer there, right? So then, for those of us that did not have cash when we bought our homes and we are still paying a mortgage for our homes, should that be taken into account? Like, how does that work if you have a home you're still paying for, and you're trying to get a trust?
So okay, so the trust is the so okay. Who is on the name of the deed is not necessarily the person on the name of the mortgage. Okay. So I could have a mortgage in my name. I see this often with like a divorce. Okay. So let's say husband buys $1 million home, and then a year later meets this beautiful woman. They get married, and he's like, baby, I love you. And she's like, well, will you add me to the deed of your home? And he's like, of course I will. You're so beautiful and I love you. Adds her to the deed. So now she is an equal joint owner of that home. But he didn't add her name to the mortgage. He is still 100% responsible for the mortgage. The bank only cares about whose name the loan is in. That doesn't have anything to do with the deed, though. Does that make sense?
Mhm.
So the trust account can own those two things are separate.
Okay. And then imagining that, there are two spouses and they're thinking through getting their affairs in order. Is the trust for both in the couple, or is the trust for one individual, even if they both own the home?
So okay, what is in the trust can vary. Like it just because there's a trust doesn't necessarily mean that the home has been added to it, right? You can add or not add whatever you want to a trust first. Second, an individual can have a trust, or it can be a family trust. So it could be like the Wynn family trust or the Price family trust, and it can cover multiple beneficiaries. It can vary. Again, trusts are dynamic and they can look like a lot of different things. And I just spoke a lot about one particular kind of trust, just to talk about for the purposes of generational wealth and protecting wealth from that long-term care. But yeah, you can do a lot of different things with trust. And to example that individual trust, if you recall, I spoke about how special needs trusts can be put in place for like incapacitated adult children. So like what happens if you're getting old in life and maybe you have an adult child that has Down syndrome and can't care for themselves. Like you want to make sure that that child has funds and that they're well cared for and that they can also qualify for Medicaid because they might need some sort of long-term assistance or care. And you still want to be able to leave them something without making it so they're not disqualified. So that would be an individual with a trust, if that makes sense.
Got it. So just to, we have a lot more questions, but we are trying to keep this just to an hour. We're gonna have a follow-up email with some resources and places that you can go for information. But there are a couple of questions I think about kind of like caring for. There's one that says if there's a only child and a parent, and the parent has dementia, but changed their will unbeknownst to the child and then passed, is there anything that can be done with that, or is that last will the standing document?
Okay, so in Virginia, to have a proper will, it requires a notarized signature. So you've got the testator, which is the person that makes their will. You're called the testator, the testatrix if you're a female. So the testator. So you're the testator, it's your will. You are signing that in front of a notary who is not going to notarize your signature unless you are over the age of 18 years old and you are of sound mind and able to make your own signature. Plus, it also requires that you're going to have two witnesses, and the witnesses are also signing your will. Okay, so you've got three different people who are there when they're signing the will. Can somebody contest it and say, "Oh, that person had dementia at the time"? Yeah, I've seen it. And then that person can go to court and they'll try to prove, like, no, mom had dementia, and so there's no way that could have been done. And then they're going to have to overcome the fact, well, three people were there who were speaking to her and making sure that, the notary was making sure the witnesses were also attesting, like, nope, this person, is of sound mind. And they're going to come in and say, yeah, well, dementia is on a spectrum and there's good days and bad days. And just because you have some bad days doesn't mean that you can't change your will on a good day. And so that's gonna be like what that looks like. But yeah, it happens and I've seen it.
Okay. And can the power of attorney file a transfer on death for their loved one if a will already exists?
You know what? I'm gonna say that you need to check with your financial institution because there's so many different kinds of transfer on death or payable on death. You need to check with the different institutions because some things are going to be guided by federal law, other transfers are going to be guided by state law, like the House. And so you will want to check with the different, assets that you have and find out what the rules are that guide what the laws require. But
Yeah.
it's usually really easy. And so, and also the other thing you're going to have to check is the actual document. The durable power of attorney may or may not even allow for such a designation because the person who makes it can make it as broad or as limited as you want. I could create a durable power of attorney that says, I own a Ford F-150. I don't. It's just an example. I own a Ford F-150, and if something ever happens to me, if I'm ever in a coma, it could be super specific. Then I want this person to sell my Ford F-150 and use my money to buy dog food for my dogs so that way nobody's worried about feeding my dogs. It can be so specific and it can name a specific car because, it can be as broad or as limited as you want it to be. So does the document allow for it? Does the federal or state law or the institution allow for it? You need to check. There's a lot of different things that are going to guide the answer to that.
And then I think this might have come when you were still talking, but can you just go back over what court conservatorship is?
Yeah. So when somebody is incapacitated, or there is a reason to, mom has dementia. Let's do the only child with the mom with the dementia example. Mom has dementia, and there's a need to place her in long-term care, but mom doesn't have an advanced medical directive. So the long-term care facility is like, well, she didn't have an advanced medical directive on file, and who's going to pay me because you can't even get into her bank account to pay us to begin with. So a advanced medical directive would have otherwise taken care of the person. The durable power of attorney would have otherwise taken care of the finances. You don't have either of those, or if you did, they were not done well. I've seen that too. People will fill out those boilerplate forms from the hospital, and then person ends up with dementia and it's insufficient to do what the people need to do. You still end up in court anyway. So don't rely on boilerplates. Don't, if you can afford it, get an attorney, and don't rely on self-help because I've been in those situations plenty in court. So anyways, what happens is you end up in court. because they didn't exist or they were insufficient. And then what you need to do, you need to get first thing that happens is a judge has to determine if the person is indeed incapacitated, because just because somebody says that you're incapacitated does not make it true. And there's a guardian ad litem that comes in to protect the potentially incapacitated adult. They speak with the medical care providers who have law guides a certain they have to go through and answer certain questions. So the medical diagnoses has to, within court, with it as guided by law, has to be submitted to the court. The court looks at all that, and then the first thing that happens is a judge will say, yes, this person is incapacitated. And that's a very serious thing to do, because that means that person has lost their right to own a firearm. They've lost their right to vote. They have lost a lot of different things. It can be temporary or it can be permanently. And so after that determination has been made, and only a court can do it, then the court will appoint a guardian, or and a guardian and a conservator. Most of the times it's the same person, but sometimes it can be two different people. So a conservator is somebody who will take care of that person's financial life. They can do anything with their finances. Small things like pay the phone bill or the electric bill, big things like sell the home, liquidate the cars. And then the guardian means they can do anything related to the care of the physical person, the physical care of that person. Oh, I can't hear you.
Thank you. I was just saying just a few more because we are running out of time. There was a question about it was the option for temporary, the power of attorney and local parentis.
Yeah.
So an example is given if a parent is like going to rehab and the grandparent is keeping the kids. Is that something that they could give so that the grandparent can take care of everything?
Because what will happen if the grandparent does not have that? It might be that, let's say the child has Medicaid. Who's going to fill out the Medicaid renewal for that child? A grandparent will need the authorization to do that. The child, only a parent is usually able to register a child for school. But if you've got a power of attorney and loco parentis, the grandparent will be able to, if it's done well. If it's not done well and you tried to do it yourself, it might at least float you until you can get into court, and the school might at least allow you a temporary enrollment until you can get into a court. But it will allow a lot of things. One thing I wanted to add unrelated to that question, and when we were going through at the initial questionnaire about the ones and the tens, I would say that I'm probably a 10, but even people who are tens can learn a lot, because there's so many things that people don't think about that can be done with wills. For example, the general rule of thumb is grandparents don't have custody rights. Okay. They don't have custody rights, but the General Assembly in 2021 passed a new law that allows for certain visitation rights under certain circumstances. So if their adult child has passed away or is deemed to be incapacitated, and if it can be proven that that now deceased or incapacitated adult parent would have wanted their parent, so the grandparent of the minor child, to have visitation, then that grandparent can get visitation. They can file a petition with the court. If it's in the best interest of the child, it's going to happen. So things that even a person who had answered a 10 might not be thinking of is a will is a great place to say that. The person's broke, they died, they didn't own anything. They should still have a will that says, if I should die, it is my intent and my will that my grandparents be able to have visitation with my children. Or I had a bad relationship with them and I don't trust my babies around them, and it is my intent that they never see my kids again. And so if you're at the other end of that courtroom, you have
Wherever you are.
you have a document that can show the intent one way or the other. So I know that was not the question. I hope
No,
I
but that
answered
was helpful.
it. And then I just remembered something else I wanted to kind of say, like, even if you're a 10, it doesn't mean you can't learn.
Yeah.
And there's all sorts of creative things you can do.
Okay, so last question. I know there are more questions, y'all, but this was only supposed to last an hour. So if you still have more questions, there'll be that follow-up email. And then you can also, go see some of the other resources. And we have an announcement of another event that you could attend. And this says, does the transfer on death wait. Oh, okay, sorry. Does the transfer of deed prevent the sale of a house?
Okay, so that is something you're going to want to check with the circuit court clerk on. You can change that. You can change the ownership of the house at any time. So to be honest, I have helped with the transfer on deed filing, but I can't, I've never actually encountered a situation where somebody then wants to sell the house. So that's a good question for your circuit court clerk. And they are there, and the law is intended for them to be able to guide you through the process. It's supposed to be a self-help process. So I don't want to give any incorrect information.
Gotcha. We are out of time, but before I give Rebecca the last word, I do want to let you know that our wonderful Newport News Circuit Court clerk is also having a webinar this week. Great minds think alike. We didn't know about each other's events, but she's having a Zoom. Angela Reason is having a Zoom about will and estate planning basics on Thursday at 6 p.m. So we'll include that. If we can get our follow-up email out before Thursday, 6 p.m., we'll include that. But you can also follow them on her social media. She has flyers up there as well. It is free and it is online. And that's again Thursday at 6 p.m., where some of these questions that were maybe not touched on, and then you guys can, I'll shoot over the question about the sale of the house so she can be ready to answer that one. Also, I want to let you guys know, like you heard uh, Rebecca say a couple of things about the law. So, what the General Assembly does on a daily basis impacts your life in all aspects. So, if there are things that you think are really important as it pertains to justice and financial equity and all of the things, you want to make sure that you have your say in electing them. And every single seat in the House of Delegates, in addition to the governor, lieutenant governor, attorney general, and then here locally, the sheriff, the commissioner of the revenue, the treasurer, and the Commonwealth's attorney are all on the ballot. And that election day is November 4th, but early voting starts September 19th. And so you want to make sure if you're a registered voter, check your status, make sure it says active. If you go in to see if you're a registered voter and nothing pops up, that means you are not in the system. So go on and register to vote. And then also consider, with everything that's going on in the world, you may just want to add yourself to the permanent absentee ballot list. And that way, whenever there's an election, you get your ballot mailed. You don't have to remember, and you also don't have to apply each time. You do not need an excuse or have to have a disability in order to join that. So we'll include that information. Also, I am serving on the Joint Commission to transfer the Commonwealth to a retail cannabis market. I am the chair of the Commission to End Hunger. I'm also on the Joint Commission of Healthcare. All of those meetings are still happening, so you can insert your public comment. Rebecca was able to come talk before the Privileges and Elections Committee the other day. So the work is still happening, even though we're technically not in session. So please plug in. You can reach out to Tempest. We can help you see where everything is going. And then lastly, on Friday, the Clips, they're having their Cousins Festival on Saturday, which I'm super excited about. But on Friday, before that, they're having Cousins Con, and it is going to be at Waterside. And you can check my Instagram and my Facebook for the flyer. It's free. You do have to register, but it's free. And we are going to have panels on civic engagement, voting rights, justice. And so I'm going to be on one of the panels. There's lots of other wonderful people that are going to be talking. So that is this Friday at Waterside, free, open to the public, but you do have to register. So check out my social media for that. And with that, we will also be having an upcoming town hall. So please stay tuned. And now, Rebecca, I just want to give you the last word if you want to reiterate any of your points.
Yeah, be a part of creating the equity towards equality, and you can do that by empowering yourself first.
Yeah, I love that you said use your voice now while you have it,
Yeah,
right? That can
100%.
apply to many things. Rebecca, thank you so much for your time. Everyone that was here, thank you so much for spending time with us. We're gonna get that follow-up email out, and also, of course, always, thank you, Tempest, for your help with this. Everyone, please be safe. Utilize your voice while you have it, and let's take action to create our will. Thank you so much. Talk to you all soon.
Thank you for having me, Marcia.
You're welcome. Bye,
Bye.
everyone.